In Florida, if a town doesn't like what you do with your lawn, you could be facing bankruptcy. Sandy Martinez is stuck with $165,000 in fines for completely harmless code violations, most of it for occasionally parking a car a little bit over her driveway and onto the grass. Jim Ficken faced foreclosure of his home because his grass grew too long while he was out of town. I'm Kim Norberg of the nonprofit civil liberties law firm, the Institute for Justice, joined by co-host Keith Neely and IJ attorneys Andrew Ward and Mike Greenberg. We're discussing Florida's devastating daily accruing fine systems, how courts have refused to stop these abuses, and how IJ is fighting back. This is Beyond the Brief. What happened to Sandy Martinez in Lantana, Florida is one of the worst excessive fines abuses that we've challenged at IJ. Mike, how did Sandy end up in this situation?
Yeah, so Sandy Martinez was our client, and she is a working class homeowner in a small city in Florida called Lantana. She works for daily wages at a medical office doing administrative billing work, and she lives in a modest home in Lantana with not just her 3 children, but also with her sister and her octogenarian mother, who she helps take care of. And they're all pooling resources all together just to try and make ends meet. And that became a lot harder for them after Lantana's code enforcement apparatus got a hold of Sandy and fined her into financial ruin, basically. It all started back in 2013, over a decade ago, when the city fined Sandy $16,000 or so because her driveway fell into what the city called disrepair, which is basically just having cracks or bald spots in the driveway, in the gravel or the concrete that the city didn't like. And Sandy, she's of limited financial means. She did what she could to kind of save up the money to get a new driveway, have it paved over as quickly as she could, but that took time. And all the while, the city is fining her every single day for having this code violation on the books.
And then there were more code violations, right?
There's about 2 years later, there's another one where her fence was damaged in a storm. It fell over kind of inward toward her property. And as she is saving up the money to get that fixed and haggling with the insurance company, the city is again fining her every single day. And that one eventually reaches $40,000 or over $40,000, I should say. And that's the backdrop where we get the most abusive fine that some of us at IJ might have ever seen. And that's when the city fined her over $100,000 for parking her cars on her own property improperly in the city's view. There are four driving age adults who lived at Sandy's house, and they all had cars. They all needed to get to and from school and work with busy schedules just to try and make things work. But the driveway was only wide enough for about 2.5 or 3 cars. And in Lantana, there is a law on the books that says if you're going to park in your front yard, you can only park with all 4 wheels squarely on the driveway. That didn't quite work in Sandy's situation. The houses, so they parked instead with 1 or 2 of the cars partially touching the front lawn, totally on their own property, totally not harming anyone. And it was not intrusive. It was better than parking on the street where it's a busy intersection. You can't just park in the street. There's no shoulder. It was better than blocking the sidewalk. But it was nevertheless illegal in Lantana. And so the city hit her with fines of $250 for every day that continued. Sandy got that citation, and she quickly fixed the problems, rearranged the cars so that they were kind of in this grassy area between the sidewalk and the street, which is legal, just a little dangerous because it's a busy intersection. There are frequently traffic crashes there. But you'd think that would be the end of it. And in the case of a normal parking ticket situation, it would. If you overstay your parking meter on a city street, you get a ticket, you pay the fine, but if the city wants to continue fining you every day, well, they have to come back and check that the car really is still there every single day, or just tow it away if it is still there. That's not how things work in Lantana. In Lantana, they presume that the violation is continuing every single day, and so the fine continues to accrue every single day until an inspector comes back and confirms that you fixed whatever was wrong. In Sandy's case, no one ever came. And so, despite the fact that she fixed things pretty quickly, that $250 fine is accruing every single day, somewhere in some city hall spreadsheet, every day for over a year, until it reaches $101,000. The only reason Sandy finds out about it is because in the summer of 2020, she's going to trying to look into putting her house on the market. And she wanted to call City Hall, get an exact number for the fines that she knew she had from those previous two cases. And someone at City Hall says, actually, there is this running fine that's been going on for over a year now. It's at $100,000. Thankfully, that person went out and sent an inspector who confirmed right then and there were no cars illegally parked. But what Sandy thought might have been $40,000, $50,000, maybe $60,000 was actually $160,000 in fines that the city had imposed on her, and that's just financially ruinous.
So
what?
Yeah,
Right.
I know.
Yeah.
It feels like there's so many crazy things that are going on in this story.
Right.
So first you have $250 daily fines for the sin of car rubber touching grass. That kind of sounds
and they'd
insane.
rather it be more dangerously parked, apparently.
Right. So there's no real connection here, from what I can tell, between this fine and the alleged violation and public health and safety. And then you have this weird mechanism by which once you get caught violating any code enforcement issue like this once, then the presumption is that you're going to continue doing it unless and until hopefully an inspector comes and checks out the property at some point in the undetermined future. Is that right?
That's right. And in that whole year where this is going on, we eventually got testimony. I'm sorry to bury the lead, but we filed a lawsuit about this.
I would hope
hopefully,
so. Right,
yeah.
right.
We eventually got testimony that the code enforcement officers are driving by every single day, and no one's bothering to check that this thing that's been going on this entire time is actually been fixed.
Mm-hmm.
They admit they had no evidence that for the vast majority of days that she was being fined that there was actually anything wrong. They it's just part of this presumption. No one as much leaves a notice on the door or gives a courtesy call or anything. And yet that's the presumption, is that this violation just continued unobstructed for over a year. And $101,000 later, that's possibly an excessive fine, as I'm sure we'll talk about today.
So, yeah, I mean, I guess the question when you're talking about is this an excessive fine is like, is the $250 excessive? Obviously, the $101,000 is excessive. Like, how do you even kind of start to untangle that?
Yeah, so we at IJ teamed up with Sandy. We filed a lawsuit in the Florida state courts under the Florida Constitution's excessive fines clause. And that was one of the two things that was really exciting about this case. One is that the Florida Supreme Court had only twice in its history ever interpreted its excessive fines clause, the last time being in the 1920s. And so it was an opportunity to kind of breathe some new life into the standard for what makes a fine excessive. In that 1920s case, all the court said is that fines that shock the conscience are excessive, which is just like saying excessive but using three words instead of one.
Sure.
And so, like, it was an opportunity to kind of shed some new light on this underdeveloped constitutional area. As far as there was precedent in the Florida lower courts in more recent years, it was going to be something of an uphill battle getting the courts that Sandy's case was in to reject a bad move that those other courts had done. They had said that in a case like this where there's the daily or rolling accumulating fine, we don't look at it in terms of the aggregate amount, the total amount that it eventually reached. We only care about whether the daily fine or the accrual amount, the $250 or the $100 that's being imposed every single day, whether that's excessive. And whether $250 for a parking ticket shocks the conscience is a much harder or more difficult question for a plaintiff to establish than $101,000 being excessive for a parking ticket.
But $250 for doing nothing wrong is surprising, right? And so like, yeah, the, first couple of days or whatever when her cars are legitimately parked illegally or whatever, okay. But then for all of these days when she had fixed it and they were still charging her.
It sidesteps the whole problem of
Right.
the city allowed these fines to accumulate by never sending an inspector to check up on her property. And there's it just kind of skips over this huge problem. And what did the courts do in our case?
Yeah, so there were several other state courts that had sort of come out on the right side of this issue.
A more rational approach, you might say.
Yes, courts in Pennsylvania and California look at this kind of what actually is happening here, not missing the forest for the trees. Unfortunately, in our case, despite some great evidence we established about what actually happened here, that fact that it was uncontroverted, that Sandy had called City Hall and even left a voicemail asking for an inspector to come out, they refused to kind of sidestep this long doctrine of saying that we only look at whether the individual fine itself is excessive. The state trial court refused to look at actually what happened, and the state appeals court sided with its kind of brethren in the other districts, saying that, who are we to second guess what the kind of elected bodies allowed or, decided what was right here.
The reason you can't look at the total, by the way, is just like a middle schooler's idea of like algebra, right? It's
What do you
like
mean by that?
because the fine, we're testing whether the fines are proportional or if they're disproportional, and it's like, well, if it's another X many dollars for another day, it's literally proportional. Like if it went on for 365 days to make the fine 365 times as much, that's a proportion. So tough.
Yeah, what
interesting.
the Steelman version of what the courts and what the government is arguing here in cases like this is not $250 for parking on your property one time or for one instance of, failing to patch the bald spots in your driveway. It's 20 or 40 or 60 or 365 instances of violating this law. And so, that's why they're only looking at the daily amount, because it's the same violation over and over and over again in their mind, not looking at actually what is going on the ground of like, this person is saving the money to fix this one problem.
Or they have already fixed it and you're fining them every day for a thing that doesn't exist anymore. Like fining me $1 for doing nothing is excessive because I've done nothing, right? Like, so this isn't the only case where an IJ client in Florida had a problem with grass. So what happened to Jim Ficken?
What's going on with Florida man? Indeed. Jim Ficken was another IJ client. He is an older gentleman living in Dunedin, Florida, which is a suburb of Tampa. And he was away in the summer of 2018. He was up dealing with his late mother's estate, out of state, and he knew the grass was going to grow while he was away, because grass grows in Florida. That happens. He hired a guy.
I've heard it happens a lot of places, actually.
Yes.
Yeah.
So grass grows in many places.
I assume it didn't come up in the case, but Jim knows his grass is going to grow. He hires a guy that he has cut the lawn to cut it while he's away. Very sadly, that man died.
Wow.
Unexpectedly. And so when Jim gets home, the grass has gotten too long. It is, in fact, over the 10 inches allowed by city code. He did wait a few days to cut it. But ultimately, the grass was too long for 57 days. A code officer came by and said, hey, man, you're going to get a fine for that grass. So Jim goes, he cuts it, the grass was cut. The entirety of the sin here is that the grass was too long for 57 days. So they fined him $500 per day and then tacked on some other costs. So they fined him $30,000 because his grass was too long.
Oh my gosh.
For much of it, because the guy he hired to mow it couldn't mow it.
Right.
Because he died.
He died, right.
Yeah.
Oh my gosh.
Yeah. And actually, it turns out that Dunedin had just a huge problem with this. USA Today ended up doing a whole expose on it. There were dozens and dozens of people who owed the town tens of thousands of dollars for things like this. A woman had given the keys to her house that was foreclosed on back to the bank, but still legally owned it, but she wasn't there. The pool got green, which can attract mosquitoes, $100,000 fine. There was a guy who fixed his own roof after a hurricane damaged it. He didn't have a permit. That was like $30,000. A different guy got fined $43,000 for something like overgrown vegetation and a pile of leaves. I personally met a woman who couldn't keep up with her lawn care because she was old and had cancer. She was fined tens of thousands of dollars. That's what they were doing.
Oh my goodness. I mean, at some point, it almost becomes perfectly clear that what these cities are doing is not protecting the public health and safety. It's about collecting money.
Yeah, and the Dunedin budget, the proportion of it that had come from these sorts of fines and fees had vastly grown over the 2010s. And, it's politically unpopular to raise taxes, but
Isolated
it's
fines.
easy to find people.
There you go.
Did you know IJ represents ordinary people, free of charge, as they fight back against government abuse? If you're looking for a rewarding way to support our work, consider becoming a member of our merry band of monthly donors and stand shoulder to shoulder with IJ's clients every month of the year. Monthly donations are convenient and cost efficient, meaning more of your money goes directly to our fight for freedom and justice. Sign up to donate today at ij.org/monthly.
I mean, the thing that kind of baffles me about this is you're finding people like Sandy, people like Jim, people like foreclosed pool lady who, like, they can't pay you $100,000. They don't have $30,000 laying around. So what's even the point of charging that much money?
I think it's to get as much money as possible. I think it's coercive. I think you can kind of get people to agree to whatever you want. If you're hanging this, giant axe over their heads, we will take all your money.
Jeez. So we get involved in a Jim case also. Tell us kind of what happens in his case.
Unfortunately, it was similar to Sandy's. We sued in federal court rather than in state court, seeking the protection of the federal Eighth Amendment, which, reminder, prohibits excessive fines. It says they shall not be imposed. And we brought this to the courts, and ultimately we lost. The federal appeals court that sits over Florida just really was not interested in these claims to the point that they actually wrote the short opinion saying we lose ahead of the oral argument and then released it that afternoon. The basic idea was like, look, the legislature, in this case, the Dunedin City Council, says you can impose a $500 fine per day for the grass. Does it matter that that's like, if we should actually look at how serious that is, like that's also the amount that you would get for like zooming through a school zone at 60 miles an hour in Dunedin. No, the legislator said that amount is appropriate, and therefore it's like, we're not going to say it's excessive because the government has said it's the amount that it should be.
So hold on, that would make it impossible for there to ever be
pretty
an
much,
excessive
because
fine.
the only excessive fine would be one that's not even authorized by law.
Right.
Or if a law had said like you can fine people, and then the president was like $1 billion, But you're right. It would basically be never, because only illegal fines would be excessive. Any fine authorized by an amount could not be excessive.
How did we get to this point? In the sense of, one of IJ's great victories at the U.S. Supreme Court, Timbs versus Indiana, we got a holding that said the excessive fines clause is incorporated against the states. In the years since...
What does that mean?
That's a great question, Kim. So when we say incorporated against the states, what we mean is that the provisions of the Bill of Rights, by their text, apply to Congress, the federal government. In a movement that started in the late 20th century the late 19th century, early 20th century, courts started incorporating the Bill of Rights against the states, meaning that even though the Bill of Rights, by their text, apply to the federal government, we're going to hold the states to that same standard as well. So in Timbs versus Indiana...
One by one. Somewhat
one.
weirdly, like you would think in 2018 that this had been settled.
Right.
And that, that stuff about cruel and unusual punishment and excessive fines, like all that stuff, surely the states can't do that. And that's always been true. But no, We had to settle it very recently.
There's still things that are not incorporated, right?
That's correct.
That's right. The quartering clause, Bill of Rights provision that prevents the federal government from quartering soldiers in your home. That's not been incorporated against the states. Hopefully that we'll never have to get to a point where that becomes a live issue that needs to be resolved. I think the thrust of my question, what I was getting at here is, we had this great victory in Timbs. The Supreme Court says, hey, this applies to the states. In some of these subsequent cases, we seem to be getting courts that look at excessive fines provisions, whether it's the Florida Constitution or the federal Constitution, and they seem not to really want to answer that question of whether a fine is excessive or not. What do you think is kind of keeping courts from wrestling with this clause? Here we are 8 years after the Supreme Court said, hey, states, you have to comply by this. Why are judges not really wanting to hold them to that?
Yeah. Well, I think there's always a pressure that the judges, we're unelected, we're the third branch, we're not. It's work to go out and say something the government has done is unconstitutional. I think there's very often a bias against doing that, and as a result of, I think, that kind of pressure, what's happening is that the courts are sort of starting to split about how to deal with this. Like, yes, everybody agrees that the excessive fines clause applies, but does it really mean anything? And so you've got some courts, like the Indiana Supreme Court, after that case went back down and actually looked at the fine in that case, they did a very individualized analysis. Like we're going to look at what this specific person did, how bad his crime was. We're going to take all that into consideration and say on these specific
His
facts,
ability to pay the fine, all sorts of things.
Yeah, this is excessive. Pennsylvania's Supreme Court does that too, as Mike was mentioning. But then you have these other courts that are kind of going, we don't want to get into that. That's, maybe too much of a role for the courts. We're supposed to stay out of this. It's only supposed to be if the fine is grossly disproportional to the gravity of the offense. So we're going to really look at this at this very high level of generality. Did the person do the thing that they're going to get fined for?
Right.
Was it in an amount that the fines are authorized? And yeah, you're right. I mean, that basically saps all the life out of the clause. If you're going to look at it like that, did you do the stuff for which this punishment exists? Did you get punished in an amount that is authorized? The protection's not worth anything then.
Right.
So one detail of Jim's case that I only learned about recently, but is crazy, is that after we sort of lost that case, the city also tried to charge him for the existence of the case, right?
Yeah. Although as a counterpunch, because we were kind of winning in the court of public opinion. So what ended up happening, as it sometimes does in IJ cases, is that even though we lost in court, ultimately we had sort of sufficiently highlighted this problem that things did start to get better. So ultimately, Dunedin decided to have an amnesty program where you could come in, apply for a fine reduction, get your fines reduced from these cartoonish amounts that, people probably weren't going to pay anyway. Jim went in and sought a fine reduction. And at first, there was this whole struggle of sure, we'll reduce your fines, but you need to pay for the deductible in our insurance because, you made us fight with you in court and we had to defend that. So we're going to tack that on as part of your fine. That you still have to pay for. Yeah. So there was some ado about that, some disagreements, strongly worded statements were sent. Ultimately, however, the city did decide to reduce Jim's fine. It came down to about $7,000, which is still
That's a lot of money still.
preposterous for having grass that's too long, but at least it's not I don't know, preposterous times preposterous, whatever it was before.
Does this reduction kind of program, is there something similar to that in Lantana, or?
There is. It's not quite as robust as the one that Dunedin wound up adopting because Andrew and co. so thoroughly bludgeoned Dunedin in the court of public opinion. In fact, Sandy's already been through it once before, and this shows what kind of actor Lantana is. Right before we filed her lawsuit, she went through this kind of process they have to petition the city, basically asking them to reduce the fine. And what they did in that case was say, sure, we'll reduce this $165,000 all the way down to $25,000. except you have to come up with it in 90 days or else this offer explodes.
Wow.
And
Jeez.
Sandy is of limited means. She didn't have $25,000 saved, couldn't get access to that kind of capital all that quickly. And so the offer exploded and we filed our lawsuit. We're hopeful that there will be some options, perhaps with non-self-destructing offers in the future. And then, perhaps we're sensing a theme here that just code enforcement in Florida writ large is just kind of out of control.
Well, that's what I wanted to ask you is this a uniquely Florida problem? Could this kind of thing happen to people in other states, or is there just something special about Florida? Like, what's going on there?
It's especially a problem in Florida, but not uniquely a problem in Florida. IJ did a study on each state's kind of statewide laws on protections for fines and fees a few years ago, and Florida scored 49th out of the 50 states. So it's definitely one of the worst ones, but this is and as evidenced by these two cases in Florida specifically, it's quite bad. But we have other cases in the courts around the country dealing with these kind of runaway code enforcement abuses. We have one on behalf of our client, the Ballards in Santa Clara County, California, who are being fined 6 figures for the heinous offense of allowing one of their employees to live in an RV on their property harmlessly.
Oh my gosh.
We have other cases that we've succeeded in winning, like in Wilmington, Delaware, getting their program where they would scrap your car and not send you the equity in it if you didn't pay a parking ticket on time. So this is a problem around the country, but Florida is definitely a place where some legislative reform could definitely be in order.
What happens with people who haven't done anything? Like you're talking about the Wilmington case, and there's, somebody parks their car illegally, you get charged, $250, they destroy your entire car, pocket the, $20,000 or whatever, instead of giving you back the, difference. We have a case in Chicago where they are taking people's cars and fining people and whatever, and our clients did nothing wrong, right? Like one lady, somebody stole her car basically and joyrided it, and then they got in trouble. But this lady is still having to pay daily storage fees for her car and whatever. Like, what happens in terms of the excessiveness kind of analysis if you're totally innocent?
So this is one of the problems with the excessive fines clause being kind of criminally under-litigated over the course of American history. Andrew alluded to this earlier, that some states are kind of finally coming around to having a robust excessiveness analysis, other states are not. And part of that is downstream of the fact that the U.S. Supreme Court hasn't interpreted the federal excessive fines clause all that much. Its first case on the excessive fines clause actually was in the late 1980s. And it's only kind of gotten attention a couple of times in the last couple of decades. But there are all of these open questions about what makes a fine excessive. Is there an exception for you can't be fined if this or that is the case? And it's totally an open question right now, and that this arises a lot in the civil forfeiture context, in the scrapping of cars context, whether the excessive fines clause requires what's called an innocent owner defense at all.
Mike, you call it criminally under-litigated. Is there a reason for that? I mean, is this a case where people just haven't had the means to file suits to challenge these sorts of fines? Or is this a case where the sort of modern, code enforcement state, for lack of a better term, didn't exist until relatively recently? Because I can think growing up, fines for 10-inch grass or fines for one, car tire on your lawn weren't really a thing. And I feel like we're trending toward a society where code enforcement is quickly becoming the tool to...
The HOAification of America.
Yeah, that's kind of what I'm getting at here. Is that what's going on? Is this the HOAification of America happening live? And is that why the excessive fines clause hasn't really been litigated up until recently?
I don't know how much they're connected, but it's definitely the case that code enforcement in the last couple of decades seems to have exploded as a tool for governments to raise revenue. I think a lot of this happened perhaps in the wake of the Great Recession, where budgets were strapped, raising taxes was unpopular. What's a way that we can kind of raise revenue? Well, perhaps it's punishing people for these kind of picayune violations. And, in the last several years, we've gotten a few more excessive fines opinions, but the U.S. Supreme Court still hasn't exactly told us what makes a fine excessive. These cases, unfortunately, Lantana and Dunedin didn't give us great progress on that front, but at IJ we're going to keep on pressing forward and trying to get the court to the Supreme Court to take more excessive fines questions and get state Supreme Courts around the country involved as well.
It's funny, the one thing that or maybe like one of two things the federal Supreme Court has really said is like, oh yeah, the excessive fines clause is incredibly important, because that's the standard for that thing about making sure it applies to the states. Like, this is a huge thing in our legal history. It dates to the Magna Carta. It was important against abuses in England. It's part of the English Bill of Rights. It mattered in the wake of the Civil War when southern states were basically like trying to fine newly freed slaves back into slavery. This is obviously like absolutely bedrock in our society. And then what lower courts have run with from that is like, yeah, but what if we just don't?
Right. What if we just don't give it any teeth at all?
Yeah.
So, Mike, you mentioned earlier the idea of, cities trying to raise revenue. And one example where we saw that was a case in Pagedale, Missouri, where the city had kind of explicitly put into its budget a line item for here's how much money we're going to, raise through fines and things. Can you tell us kind of what happened in that case? How did that resolve?
Yeah, so that's a great example of one of these kind of post-Great Recession cities just using ticky-tack code violations to fund itself. And they were
mismatched drapes.
Yeah, they were fining people, hundreds and thousands of dollars, and the entire populace of the city for things like mismatched drapes and chipped paint and, grass being an inch or two too tall. Ticky-tack violations that, like, pretty much everyone can agree didn't have any actual impact on health or safety, but by fining people for whatever code enforcers could find, it could raise revenue for the city. And IJ sued about that in the mid-2010s, and it's one of our great successes in the fines and fees arena. We got the city of Pagedale agreeing to a consent decree, which is basically a settlement in which the judge also enters an injunction forcing Pagedale to abide by it, where they repealed a bunch of the offending ordinances. They established a bunch of new procedural protections for people that are going to be cited. And just generally speaking, Pagedale is a much better place to live now. It's a model for what we hope to see other cities in places like Florida adopt going forward.
Speaking of moving forward, Andrew, what's the next step for IJ in this space? You mentioned kind of this ongoing circuit split or the struggle that courts are having in kind of how to actually apply the excessive fines clause. I know we have a case about that. Could you talk a little bit about it?
We sure do. And answer number one is continuing to litigate all sorts of these cases around the country. But in particular, we have a pending petition at the United States Supreme Court. It's Mike's case, but it's really cool. So I'm excited that I'm just going to talk about it instead of him, which is about resolving precisely that question. Do you look at the offense at this kind of like astronomical level of abstraction, or do you get into what the person actually did? In this case, it's about a pilot in Alaska, Ken Jopi, who was running an air taxi service, flying, it's a big remote state, flying to these different towns. Some towns in Alaska prohibit alcohol because of, alcoholism is a real problem. And according to a criminal conviction, he disputes this, but we'll take as true that Ken knew that one of his passengers had a 6-pack of Budweiser. She was taking it to her husband's birthday party when he flew her into one of these dry towns. And so he actually got convicted of bootlegging under a bootlegging statute. He got fined $1,500. And then also they seized his entire plane. They said, because, this is part of this crime, you flew this 6-pack, we are taking your entire plane that's worth, more than $100,000. And what the Alaska Supreme Court said in evaluating whether that was an excessive fine is basically just, well, that's what the statute says. You did it. The statute was passed because alcoholism is bad. And this is what the legislature thought is appropriate. So yeah, not excessive at all. And we of course think that, no, you need to look at the actual individual facts, which is that forfeiting a plane for a 6-pack is ludicrous.
Right.
Its analysis would have been absolutely no different whether it was Ken Jopian turning a blind eye to a passenger six-pack, or whether Ken himself was like the Pablo Escobar of alcohol in Alaska, which is exactly the sort of thing that went wrong in the Dunedin case of like, is this the kind of fine appropriate for tall grass, or is it the kind of fine that's appropriate for, like, I don't know, what's the worst thing you can do in a code violation? Like leave your roof with a sinkhole in it for like 6 months on end.
I don't know about roof sinkhole. That's a no, but yeah, like it's like something incredibly dangerous,
Yeah.
and but that's of course not happening. Like we took deposition testimony. They're like, asking these guys like, was there a problem with the grass? I didn't see one, but there could be. It was like, there could be critters. And it was like, all right, well, did you see like an alligator eating small children hiding in the grass? No.
Oh
but,
my gosh.
But could happen.
I mean, and I'll buy, like, yeah, there's, this much, health and safety concern with super tall grass, whatever. Like, I buy that. Is there, $30,000 worth of danger in that?
There
I
is not.
feel like
not
no.
with this guy's grass.
To sort of wrap up, it seems like kind of a lot of this conversation has been, this is all very hard and kind of bleak a little bit. What gives you optimism about the future in this space?
It's certainly hard, but we win these cases. We lose them and we win them. It is hard. Constitutional litigation is hard in general, but I mean, in terms of we've gotten those consent decrees. We won Tyson Timbs' case both at the United States Supreme Court and then on remand in the Indiana Supreme Court on its
like 3
third
times.
trip there. Yeah, we kept winning that case. We've had a case about asset forfeiture, which is considered a fine enjoined throughout in an entire state because it was unconstitutional. I think you can win these cases. We're always happy to go bring on the next one and do it. And like, yeah, it's hard, but it should be done, and we're doing it.
If you're winning all of the cases, what you're doing isn't hard enough. And
yeah, man.
Yeah.
I think that's a good note to end on. Thanks so much, guys, for coming in and talking with us today.
Thanks.
And thanks to all of you for listening and watching. If you'd like to get more of these videos, you can like and subscribe to our channel. And if you'd like to support this work, you can join us with just $5 a month at ij.org/monthly. Thank you.
Thanks again for watching. Make sure to like, subscribe, and tune in for more videos.